The rights of all eligible citizens to vote are the central pillars of our democracy. They are the rights from which all other rights ultimately flow. 2 weeks ago, I spoke about our country's history of expanding the right to vote. I noted that our progress on protecting voting rights, especially for Black Americans and people of color, has never been steady. Moments of voting rights expansion have often been met with counter efforts to curb the franchise. Among other things, I expressed concern about the dramatic rise in state legislative actions that will make it harder for millions of citizens to cast a vote that counts. I explained that the Justice Department is rededicating its resources to enforcing federal law and to protecting the franchise for all eligible voters. And I promised that we are scrutinizing new laws that seek to curb voter access, and that where we see violations of federal law, we will act. In keeping that promise, today the Department of Justice is suing the state of Georgia. Our complaint alleges that recent changes to Georgia's election laws were enacted with the purpose of denying or abridging the right of Black Georgians to vote on account of their race or color in violation of Section 2 of the Voting Rights Act. Several studies show that Georgia experienced record voter turnout and participation rates in the 2020 election cycle. Approximately 2/3 of eligible voters in the state cast a ballot in the November election, just over the national average. This is cause for celebration. But then in March of 2021, Georgia's legislature passed SB 202. Many of that law's provisions make it harder for people to vote. The complaint alleges that the state enacted those restrictions with the purpose of denying or abridging the right to vote on account of race or color.